next matter to come before us this morning is State of Ohio versus James Kuruc. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you, the appellant, wish to reserve some time, if you let me know when you get started, I keep you clock this morning and keep you apprised of the passage of time. We've read the briefs, we're ready to proceed when you are.
Just one moment, Mary. Good morning, Your Honors. My name is Mary Catherine Corrigan. Until about 4 weeks ago, I was Mary Catherine O'Neill, and I did put in a notice of appearance on May 2nd, 2016, for our number 0091210. And I'm here with my co-counsel, Morgan Caruso. Your Honors, today I would be arguing the first and fourth assignment of error, and I'd ask that I have 7 minutes for those assignments. And Ms. Caruso will be arguing the second and third assignments of error, and we'd ask that she have 6 minutes with 2 minutes reserved for rebuttal. Thank you. Your Honors, I'd like to begin with the first assignment of error. The trial court erred by failing to grant the motion to suppress in this case. As I am aware, the court did read the briefs, and as you're aware, that suppression was broken into two components. The statements made by the appellant were taken in violation of his Garrity rights, and the statements made by the appellant were taken in violation of his Miranda rights. If it pleases the court, I'd like to first discuss the violation of the appellant's Garrity rights. The United States Supreme Court in Garrity indicated that when an employee, specifically a public employee, believed that they must make either an incriminating statement or lose their livelihood, that statement is compulsory in nature and violates the 14th Amendment and the right against self-incrimination. And that is exactly what happened in the instant matter. Our client, Mr. Kuruc, was a 22-year-old firefighter at the Grange Fire Department. He was taken into the fire chief's office. The door was closed. He was there with 4 other firemen, 1 from a different district and 3 from the Grange Fire Department, 2 of which were his direct supervisor, Chief Paulette, and Kevin Hilbert. Mr. Hilbert was there as the president of the Firefighters Association, and his testimony was very clear. This was a personnel matter, that's why the door was closed, and he, as the president of the Firemen's Association, was there in order to protect the appellant. That makes it very clear that Mr. Kuruc was in a situation where he either cooperated in a personnel investigation or he could face discipline. That was evident through the testimony at the motion to suppress hearing. Mr. Kuruc was told relentlessly, over and over and over again, that it was in his best interest to tell the truth, and that they already knew the truth. So basically, in an employment situation, they told him they know what it was, and he just needed to say it himself. That is compulsory. He was faced with losing his livelihood, which he went to school for, which he studied for, which is very difficult to get onto a fire department, or doing what they had told him was in his best interest, which is making the confession, which violated his Garrity rights. The state makes a feeble attempt to say they never told him, they never came out and directly said, you'll lose your job if you don't make these statements. But I believe it's Graham, which is an Ohio State Supreme Court case, says, well, certainly if they'd said that, it would have triggered Garrity. But the presence of those words alone, them telling you you'll lose your job unless you cooperate, isn't necessary to trigger Garrity. And I think in this case, it very clearly was. He was in a personnel meeting with his supervisor, and who appeared from the testimony to effectively be the union rep or the union president for his protection, and told it was in his best interest to make a confession to something they already knew the truth about. I think there's no question that Garrity was triggered and that the trial court erred in failing to suppress those statements under Garrity. If this honorable court finds that Garrity wasn't triggered, I think it's quite clear that the Miranda warnings were triggered. The Ohio Revised Code is riddled with instances of firemen being intertwined, firefighters and fire departments being intertwined with law enforcement officers. And that's why we have this issue here. Ohio Revised Code Section 737 indicates that every single city in the state of Ohio must have a Director of Public and Safety Service, an umbrella under which the firefighters and the police both stay. Furthermore, Ohio Revised Code 2909.01 defines firemen as peace officers and emergency personnel, and Section 2917.11 says firemen can investigate crimes and bring about charges. And that's exactly what happened in this situation. The testimony was clear that the Copley police declined to bring charges against my client. So, the victim, SK's father, got together, he's a fireman, he got together a band of his lifelong firefighting friends, some of which were my client's direct supervisors, and they enacted their own brand of vigilante justice. They came in a meeting pre-organized, and we know that because at least 4 days prior, the chief firefighter had talked to Deputy Prees of the Medina County Sheriff's Department about this investigation.
Can I ask you a question?
Yes.
At the time of this meeting, was it known at that time, and had anybody already done, since you're telling me that 4 days ahead of time this was planned, at that time, did they know that your client had used his code to go into the fire department after hours?
I believe so. I think
Did
the
they do that at the time?
Yes, I think the testimony, and I think that came through in SK's testimony as well as some other testimony, was that SK was found with another adult male, got in trouble for being with that adult male as his parents were finding out for the first time that he was gay, and in the course of that interaction expressed to his father, Mr. Kolner, and I hope I'm not mispronouncing his name, that he had been with another adult male, my client, and that they had actually been together at the fire department.
Yeah, but my question is, at the time they had that personnel meeting,
Yes.
it was known at that time that he had used his passcode to get into the building after hours, or when, was he approved to go in at that time?
I don't know if he was approved to go in, I don't have an answer.
Did he end up losing his job
He did lose his job, Your Honor.
because of this?
Yes.
Is that in the record?
I believe it is in the record. It's certainly, I believe, is supported through the record. I don't know that he lost his job. I don't have an answer to whether or not he lost his job because of the subsequent conviction for a sexually oriented offense and felony, or if it was as a result of the
So you don't know
internal
when he lost the
investigation.
job, when he was fired? You don't
No,
know when
I
he
don't
was
have the answer to
So
that.
it wouldn't be in the record, because if he lost his job after the fact, then that wouldn't have been something that's presented during trial.
I don't have an answer. I don't know that. off the
That's
top.
fine, that's fine.
And I need to let you know that you're encroaching on your co-counsel's time. However you guys want to split it up, it's fine with us.
Thank you. I'll be quick. The second issue, or the fourth assignment of error, was that the trial court erred in failing to advise my client of her conflict and allowing him to waive or either invoke that conflict. It was a practice in Judge Joyce Kimbler's courtroom when she took over her husband, James Kimbler's docket, to advise and have executed a waiver of any conflict. That was not done in this case. The Code of Judicial Conflict says that they must make that known, and Section 2.116 indicates that they shall recuse themselves if their spouse had been the prior judge. This is a unique situation, but our client should have at the very least had the opportunity to investigate that situation, specifically.
Counsel, I'm sorry, I know you were trying to get a lot of stuff in because we're running out of time. But even if all that's true, how do we rectify it? We don't have any jurisdiction to do anything about that.
I think that the rectification of that situation is a reversal and remand for him to either invoke or waive that conflict. I think absent that, this wasn't and as a side note, the code is non-discretionary. It says shall.
But that's enforceable in the Supreme Court, right?
And I think that in this situation, a reversal and a remand for it to be reassigned to a different judge would have been appropriate. The most egregious cases in our justice system are those involving children in sex cases and public servants abusing their office. And this is a unique case where we have this judicial conflict, but we also have the two most egregious types of crimes that we see. So with that, I will turn it over to my co-counsel for the remainder of the argument.
Good morning, Your Honors. Thank you, Ms. Corrigan. Your Honors, Morgan Caruso on behalf of Mr. Kuruc. I'll begin with the second issue. The second assignment of error here is whether the guilty verdict can be upheld because clearly it did not establish the appellant's guilt beyond a reasonable doubt. Point to the elements of the offense. Both counts 1 and 2, unlawful sexual conduct with a minor, require that the state prove, of course, beyond a reasonable doubt that the appellant engaged in sexual conduct with another, here SK, either knowing that that person was 13 years of age or older and under 16, or that he acted reckless in that regard. The only piece of evidence at all whatsoever that came into trial to support that was the testimony of SK. This is a person who had already lied about his age, lied to get himself on the website Grindr, lied to his parents about where he was going, both with regards to the appellant and Matt Payson, who was the other adult male who he had relations with, lied about even being gay, lied about how many times he had lied to the point where even his parents weren't sure whether to believe him or whether or not he was lying. This is so important because as we know that yes, one person can testify and that is sufficient to potentially meet that element, it's so crucial that the credibility is evaluated. And here, so clearly, this person's testimony had been so riddled with lies already that we couldn't possibly allow it to meet that burden. The state, in its brief, which submitted that it was verified the age of my client, that they had discussions regarding that he had an associate's degree and that they had had discussions about his age, and the issue here wasn't so much his age, it was of course the age of the alleged victim.
And the whole issue at trial was whether he knew this was a minor, right?
That's correct, Judge Carr.
What statements did he make, I can't remember right offhand, but what statements did he make during that personnel meeting, we'll say personnel meeting, the meeting, that said he knew he was underage?
Well, actually, in that meeting, Judge, there were some very specific inconsistencies with the age that draws upon the actual confusion that was occurring there. It was actually very clear in that communication, and I believe it came through in the testimony of Kevin Hilbert, that even he couldn't recall what James Kuruc said in regards to the age, because first he believed that he had said he thought SK was 18, and then he later said that maybe he said that he believed he was 16 and then 15. Of course, he learned in that conversation the true age in this 4-on-1 bombardment by these adult males and the father of SK, who are then telling him the age.
I guess my question to you though is, what inculpatory statement was admitted about the victim's age that was gathered from the defendant at the personnel meeting? What was admitted? What was the statement that was admitted?
Judge, it was more so the admission that the sexual conduct had occurred, and then coupled with the fact that they're now suggesting there was knowledge or recklessness. See, that's the problem. The admissions were made as to the sexual conduct, but then we have to meet this other prong, this other element, which is the knowledge or recklessness, and it's that part that just wasn't there.
How about, here we go.
No, go ahead.
When the defendant here, the appellant here, actually goes to SK's house to pick him up in the middle of the night and then sneak him back in before mom and dad get up in the morning, I mean, isn't there some inference there that perhaps this kid isn't 18?
There could be, Judge
So wouldn't
Schaefer.
that be sort of reckless?
Well, it could meet recklessness, but here I would submit that it absolutely did not. See, my client as well lived with his parents.
He drives.
I'm sorry?
But he drives and doesn't need to sneak in before mom and dad wake up.
Well, he lives with his parents, and I think that the sneaking in part had more to do with the fact that he was going out with a male. See, we have to remember that this father, these parents, when learning of this, and apparently didn't know about it before, were so angry to learn that their son was going out with a male in the middle of the night. It wasn't so much that he was going out and that they're the parents and he's this young person. This had to do with the fact that a male was picking him up. And so my client was certainly under the reasonable impression, you know, because they had this discussion, have you come out to your parents, that this is why the secretiveness was there. So while that is an excellent point and could have been used to consider recklessness, the problem here is that there's just not enough.
And if you're going to need to conclude if you're going to reserve any rebuttal time, you can approach the rebuttal time.
Thank you, Your Honors. I would lastly just point to the third assignment of error. I know you've read the briefs. I would indicate that much of these things, when looked at individually, might not have necessarily made a difference, but when viewed in the aggregate, the counsel's errors would have made a real difference in the trial. Certainly, he failed to bring out how coerced all of SK's interactions were with the police, Detective Cartwright, the fireman buddies, all of the testimony, all due to the presence and disappointment of his parents. He lied about his age. The appellant never knew his true age during their physical encounters or communications together. We just have this person saying, well, they discussed it 4 times. It was never discussed. He didn't act recklessly. And the fact that there was no closing argument as to that and that records weren't subpoenaed from Grindr is absolutely an issue. We're left with so much guesswork. And I would absolutely indicate that much of that would have made a difference. The failure to examine the role of the Firefighters Association, whether it was a union or what, and incorporating the argument of my co-counsel, knowing the involvement of the Firefighters Association and how that had a bearing on his employment would have absolutely allowed us to know whether or not those statements should have been suppressed under Garrity. So much of this wasn't done as well. I thank you all for your time. We would like to still reserve time, for rebuttal.
Actually, I allowed you to go past the full 15 minutes at this point. So thank you very much. Thank you both for your presentation.
Thank you, Your Honors.
Morning, Your Honors. My name is Vince Vellucci. I'm an assistant Medina County prosecutor for the appellee state of Ohio in this case. I will start with the motion to suppress, where we actually had 2 issues raised, Miranda and Garrity. I know they spent most of their time on Garrity, so I think I'll try to do that as well. The Miranda issue here is very simple. We know that under Miranda, custodial interrogation is questioning initiated by law enforcement officers, that being the operative phrase, after a person has been taken into custody or otherwise deprived of their freedom in a significant way. But then we have the Ohio Supreme Court in the 70s, in the case of State v. Bolin, clarifying that the duty of giving Miranda warnings is limited to employees of government agencies whose function is to enforce law, or to those acting for such law enforcement agencies by direction of the agencies. It does not include private citizens not directed or controlled by a law enforcement agency, even though their efforts might aid in law enforcement. So Bolin is 27 Ohio ST2D 15. Kuruc's motion is obviously based on this firehouse meeting. It's undisputed that none of the four people in that meeting with Kuruc were members of law enforcement. They were firefighters. And none of them were directed by law enforcement to have that meeting. In fact, the testimony that came out at the suppression hearing was exactly the opposite. Sheriff Detective Prees, I heard him mention, he actually testified that he was not told about the meeting until after it was held. And in fact, he was upset when he found out that the meeting took place because he thought that it might hinder his investigation. 4 days before the meeting, it is true, Chief Paulette had told Detective Prees about the alleged incident with Kuruc and SK, this alleged incident, but he did not say anything to Detective Prees about this meeting that was to happen 4 days later. That was the testimony. As for the meeting itself, in terms of the physical layout, Kuruc sat in a chair that was closest to the door. He had no one between him and the door. SK's father and Kuruc were the ones that did most of the talking, with the father basically asking Kuruc questions and Kuruc answering them. This was a very civil discussion. This wasn't something that got heated. There were no voices raised. There were no threats made. There was no talk of criminal charges being filed. The father ultimately did tell Kuruc to stay away from SK at the end of the meeting. But that was basically it. I'd like to move to Garrity now. And we know that statements obtained under threat of removal from public office cannot be used in criminal proceedings. When we have no express threat, I know State v. Graham was mentioned, and that is the standard, the Supreme Court standard. That's 2013 Ohio 2114. And that's the test that's set out when there is no express threat, which there was not here. First, the person being Kuruc in this case must subjectively believe that he'll be fired for asserting his Fifth or Sixth Amendment privilege, and two, that belief must be objectively reasonable.
Is the record going to reflect that the testimony about who said what at that meeting is consistent, or is it in conflict about everyone's recollection of who said what at the meeting?
I don't think there's a whole lot in the record about what was said in that meeting. I think it's mainly based on Mr. Heilbert, I think that's how you say it, and a memorandum that he produced based on some notes that he took in that meeting.
And I can't recall from my review of the briefings then, but was there an objection raised at trial as to the defendant's statements being utilized?
There was obviously the motion to suppress was filed, and there was a suppression hearing based on his statements being suppressed. That was obviously denied. I was going to get into this a little bit later, but in terms of what was actually said in that meeting by Mr. Kuruc, it was very vague. It was a vague discussion at best. SK's father.
Vague discussion at motion to suppress hearing?
No, I think that the testimony was that in the meeting it was a vague discussion. In fact, the notion of whether sexual conduct had occurred, it was never even stated by Kuruc in that meeting that he had engaged in sexual conduct with SK. He basically just stated that they had fooled around. And then SK's father basically stopped him and said, I don't want to hear any more about this. And they kind of just sort of moved on. I don't think in terms of his age, whether the knowledge of his age was necessarily discussed in terms of I knew he was exactly 15 years old when I did this. And that also goes to the ineffective assistance of counsel argument. The fact that even if Kuruc's statements from the meeting had been suppressed, it would not have changed the outcome of this trial. This trial was based mainly on SK, the victim's testimony. And I'll get into that a little bit more with the manifest weight argument.
But at least there was some corroboration, even if he just said we fooled around.
Correct.
It's
was.
not just,
That's right.
just a wild allegation from a 15-year-old, let's say.
It was absolutely corroboration, but without that statement, my point is, I guess, that the state still had its case. It had all the elements, was provided by SK's testimony, would not have changed the outcome of the trial, most likely, if those vague statements had been suppressed. But
So you're trying, and that's what I was getting at earlier in questioning appellant's counsel. What statements were actually admitted? Were they inculpatory? Was there actually, because usually you try to suppress statements because it's a confession, it's inculpatory, those type of things. If it's not, it doesn't mean anything.
yeah, and I think there were some inculpatory statements, the fact that he admits they did fool around, but that whole thing, but there wasn't enough detail for that to basically sustain the state's case on its own. The state needed SK's testimony to prove all these elements, and that's exactly what they had.
But what does that mean? I guess this is a little unusual, so I'm trying to figure this out. Let's say that the clear-cut cases, he says, oh yeah, I had sexual conduct with him, conduct, whatever, whichever one. And this is what we did, and I knew he was 15. That's clear, that it's obviously a confession, inculpatory statement. And if it was a violation of Miranda or Garrity, it should be suppressed. And the trial court erred in not doing that. So in this case, you're saying it's a little bit more vague as to what he said, although some of the statements could be considered inculpatory.
Correct.
All right, so, and you're saying it wouldn't have mattered for purposes of ineffective assistance of counsel, but regardless, it would have mattered for the presentation of the case, though, right?
Somewhat, yes.
The point is, if the trial court erred in not suppressing these statements, then it has to go back, right?
Correct, but I would go back to my original argument. There's no error here. I was kind of in the middle of my Garrity argument. First of all,
We do this to you, we just interrupt all
Yeah.
over the place and take him off.
but I would just get back to the first prong, Kuruc's subjective belief that he would be fired. There was no testimony by Kuruc at the suppression hearing that he thought if he didn't say these things, he was going to be fired. So there's no evidence that he subjectively believed he was going to be fired. So right off the bat, we don't have the first prong. Then you get into the objectively reasonable, objectively under the circumstances. What's the situation here? That's a totality of the circumstances. You look at everything and say, would he be reasonable in believing under the totality that if he didn't give inculpatory statements and waive his Fifth Amendment right, that he'd be fired? And I think if you look at the totality, that wasn't reasonable either. We know the testimony is unanimous, that this was pretty much a cordial discussion between these two men. Other people were silent. There
Well,
were
why
no
would you have
threats.
a union rep, why would you have a direct supervisor, why would you have a meeting at the fire station? I mean, it'd be different if it was at a coffee house, you know, and you said, let's meet at Starbucks, and a couple colleagues went with the father to just tell him to stay the heck away from my son, which is what supposedly this was all about. But it doesn't have a feel of that, does it?
Well, I think part of it had to do too with the fact that the incident was alleged to have occurred in the firehouse itself. And he had
So
actually
what does that have to do with anything?
well, as you mentioned, he used his passcode, abused his position to get into the firehouse.
But that makes it sound like it's personnel matter, though, that he's looking at whether or not he's gonna keep his job.
But I guess the point is, he was never asked to incriminate himself necessarily. It was never implied that he would lose his job or that he should resign or anything like that if he didn't say anything. He was never confronted with this choice between making an incriminatory statement or being fired. Like I said, it was a brief.
But even if you use your passcode to get into the fire station after hours, I mean, that in itself would be, I might get fired for that, because I was in here and I wasn't supposed to be, and they know it. Even without having to do anything with SK at all. That alone would be, gee, you know, I probably, and they're telling me they already know, and it's been.
Absolutely, that's my point also. This is more, I mean, he's trespassing after hours regardless of what happens after that. It's a matter of, this is what's going on in our house right now, in our firehouse. It's not necessarily all this stuff about did sexual conduct occur or not, you know. So I think that's an excellent point, actually, that this was not about criminal charges. This was about a father getting some answers, getting some very preliminary and vague answers at this point. This was not a custodial interrogation. On manifest weight, I'd like to just move there real quickly. We know obviously that the trier of fact has the right to place considerable weight on the testimony of the victim. And here we had SK, obviously, as the state's main witness, as I mentioned. Kuruc is challenging the evidence that he knew, Kuruc knew or was reckless in regard to the fact that SK was between 13 and 16 years old. But SK's testimony was actually very clear on this point. SK testified in no uncertain terms that he told Kuruc he was not only underage, but that he was exactly 15 years old. And SK testified that the subject of his age came up at least 4 times throughout the evening. There's no indication whatsoever that this testimony was coerced in any way. There's the challenge of the evidence that Kuruc and SK actually engaged in sexual conduct. And SK was very clear on this point as well in his testimony. He testified that he and Kuruc engaged in both oral and anal sex, both of which meet the statutory definition of sexual conduct. He argues that there was no physical evidence here, which is true, but neither this court nor any Ohio appeals court has held that physical evidence is required to prove the charge of unlawful sexual conduct with a minor. In fact, this court rejected a similar argument a few years ago in State v. Sato. That's 2013 Ohio 1320. And also, I'd like to just get back to the ineffective assistance. There were several arguments made, both about the suppression and the trial phase. We already did kind of get into the suppression, where the closing argument was basically waived in the suppression, and it was, I believe, waived in the trial by trial counsel. I would point to the Ohio Supreme Court case of State v. Burke here, B-U-R-K-E, 1995, Ohio 290. And there, the Supreme Court of Ohio said that the waiver of closing argument may be based on strategic or tactical considerations, and it's not ineffective assistance of counsel per se. In more general terms, the Supreme Court of Ohio has also held that debatable trial tactics are not a deprivation of effective counsel. I point to State v. Phillips, 1995, Ohio 171, for that proposition. The idea that Kuruc's counsel did not pursue on cross-examination enough the issue of whether Kuruc did or did not know the age, that's totally belied by the record. This was thoroughly pursued by Kuruc's counsel. In fact, it was the very first thing that Kuruc's counsel questioned SK about, was this fact that he lied on his Grindr profile about being 18. That wasn't in dispute in the case. I would point to pages 80 and 81 of the transcript. Subpoenaing SK's Grindr records would not have added anything to Kuruc's case, because SK admitted on both direct and cross-examination that he lied about his age on his Grindr profile. That question was, like I said, not in dispute. But more importantly, SK immediately goes on in his testimony to say that Kuruc actually contacted him, and he told Kuruc right away that he was only 15 years old. And then they proceeded to discuss it again, at least 4 times throughout the evening.
And counsel, you're going to need to wrap up. You'll be the last 15 minutes.
Okay. So to conclude, the State of Ohio respectfully requests that this court affirm the judgment of the trial court. Thank you.
Thank you all for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we mail to both sides, as well as posted on our website and the